Okay, so we're going to go forward with item 4D, which is amendments to Title 17 of the Malibu Municipal Code, Chapter 17.46, which is the wireless telecommunications antennas and facilities, and sections 2.2 and 3.16, Chapter 13, and Appendix 1, which is Table B, permitted uses of the local coastal program local implementation plan to modify regulations, procedures, and application requirements for the installation of wireless communications facilities. Can we have a report, please?
Good evening, everyone. My name is Gail Karish. I'm a partner at Best and Krieger. I practice in telecommunications, and I'm going to give you a very brief presentation. I know we had a study session earlier, so I'm just going to run through a few slides just to point out or remind people of some of the limitations on local authority. And so as an overview.
With that said, let's go to the public speakers.
Yes, so we have 17 speakers and then some time deferrals as well. So the speakers are Mark Graham, Scott Dietrich, Liz Barris, Craig Hill, Joe Drummond, Nicole McGinley, Akai Ming, Jenny Rosinko, Stephanie Sunwoo, Jeff Laux, Stephanie Cason, or Chasion, I believe, Linda Gibbs, Susan Foster with 5 people ceding time to her, Tony Simmons with 5 people ceding time to him, and Scott McCullough with 5 people ceding time to him, and then Lonnie Gordon and Jessica Isles.
Okay,
So
great. Thank you.
Our first speaker will be Mark Graham.
Okay, thank you very much.
All right, can you hear me?
Yes, I can hear you, Mark.
Good evening, Mayor Pierson, council members and staff, Mark Graham, Elk Grove. Thank you for this opportunity. Last Friday, I sent you 2 emails about the significant gap in coverage and the court opinion in the Ninth Circuit from last year in the case of City of Portland versus United States. Today, I sent you an analysis by attorney Andrew Campanelli of the FCC Order 18-133 and its effect on the city's regulatory power over cell antennas. I hope you had time to review those on short notice. As of today, the controlling case law on an effective prohibition of cell phone service in the Ninth Circuit is Metro PCS versus City and County of San Francisco, 2005. The way it works is this. If the city says in your municipal code that the applicant has to prove they have a significant gap in coverage and that their proposed cell antenna is the least intrusive means of closing that gap, then they have to prove it. If you say it's required, then it's required. If you say that you will require drive test data, as the FCC requires, as evidence, but you will not accept propagation maps unless they give you all the data, the model, and the assumptions behind the propagation maps, then that's what's required. You see, the city has the ability to essentially create your own court for reviewing cell antenna applications. It's not a court, but it's like a court. You make the rules of evidence and you say what is required. In your court, you make fact-finding determinations that support either allowing or denying the application for a permit. Now, the U.S. District Court is not going to overturn your fact-finding determinations, but if the city has failed to create this court, which is really your process for reviewing applications, the U.S. District Court will nail you. It will say you cannot deny their application because they failed to do something that you did not require. Does that make sense? If you say it's required, then it is. If you say these are the rules of evidence, then they are. If you make fact-finding determinations based on your requirements and your rules of evidence, you will be fine because the U.S. District Court is not going to overturn that. The only way you could blow this is exactly what staff has proposed, which is for the city to fail to set all this up, to fail to say this is required and these are the rules of evidence. Verizon agrees with me. They mention the significant gap in coverage on 5 different pages of their letter, pages 3, 11, 12, 13, and 15. Please ask your attorneys whether the city has the regulatory power per the TCA and current case law to do what I have described. You do have that power, and I am asking you to get your attorneys to tell you that. Your residents will be grateful, and so will I. Thank you.
Thank you, Mark.
Our next speaker is Scott Dietrich.
Thank you. Can stay on a second, Scott, if you could.
Yes.
I'd like your opinion on what Mark Graham spoke about as far as having to prove that you had a significant gap coverage. And the reason that worries me in Malibu is because of our topography. And that's where the 1,500 feet, 1,000 feet, 500 feet also worries me. We know that the topography makes a difference. So I'd love to get your take on what Mark had to say in relationship to the court cases he pointed out.
Yeah, and I'm gonna say this up front. I very strongly suspect that your legal counsel is going to disagree with what I'm about to say.
Yeah, and I'm going to ask Trevor also. So I'm not
okay.
Trevor out.
Soon after the Ninth Circuit panel rendered its opinion, I filed a writing with y'all that said that the significant gap test remains alive and well in the Ninth Circuit. And I remain of that opinion. I think that if you read the panel opinion very closely, you will see that they basically just interpreted the FCC's new test, or what the FCC spelled out as its test. The Ninth Circuit panel said that it's really no different than the Ninth Circuit precedent. Now, many may disagree with that, but the way I read that opinion, I do not read that panel opinion to overrule the circuit previous precedent, which was a significant gap test. Now, having said that, when you look at what has actually been proposed in this ordinance, to be candid, we kind of danced around that issue. And as a practical matter, that is something that will just, under your ordinance here, it's before you, with the green language, will probably have to be fought out in the first couple of applications. The language says that in certain circumstances, the applicant will have to show by clear and convincing evidence that it is facing a effective prohibition as defined by federal law. And it leaves it at that. And so I can imagine in a proceeding, people will be able to lay out their legal theories about what the federal law is in this circuit, and specifically whether the old Ninth Circuit test remains or whether the way the FCC is trying to steer it to be the case. Now, I'm hopeful that I'm in one of those applications and I get to deal with the wireless provider and build a good record for you so you can make a decision. I think your current words are adequate.
Say that again.
I think your current words in the ordinance before you are adequate to preserve that issue for later development on a case-by-case basis.
Okay. Trevor, do you have comments on that?
Sorry, I missed the original question. I was trying to put together some language here.
I was trying to understand or get opinions on what Mark Graham had to say about proving significant gap in coverage.
You should probably pass that to Gail on that one.
Okay. Thank you.
Sure, I'm happy to answer that. So I think I mentioned earlier, and I think Scott has said that he takes the same view. Because there is some uncertainty about what test might apply for an effective prohibition, it's best to stick with the language that's in the federal law. So that's why we use that language and not any specific test. The one issue that in particular that I want to take some or express some objection to in what Mr. Graham said is that he was proposing, as I understood it, to have an application requirement that the applicant demonstrate that there would be a significant gap in coverage and least intrusive means. There are two problems with that. One problem is that it would require an applicant to submit, it would require you to decide what is the appropriate test for an effective prohibition. So it kind of undermines the whole point of just using the federal language. The second thing is that what we have adopted or what we have structured here in your ordinance is that you set certain standards and requirements, and then you have a process for asking for a waiver if the applicant can demonstrate that there's an effective prohibition. If you put in your application requirements that every applicant has to demonstrate an effective prohibition, then basically you're asking every applicant to submit the requirements for a waiver.
Well, and that's actually one of my questions, Gail. Could you just quickly walk us through the waiver process and what that entails?
Sure. So the waiver process, I just want to pull it up here. So you've got an ordinance and resolution that have certain standards, basically your development standards and location standards. And if an applicant finds that as they're developing their project, finds that there are one or more standards that they feel compliance with them would create an effective prohibition or otherwise violate an applicable law, then they can make a waiver request. And so the waiver request is really intended to be a means for an applicant to say, in my particular project, if you require me to meet this or that standard, and you would deny my application because I could not meet that standard, that would create an effective prohibition of personal wireless services or otherwise violate applicable laws or regulations. And so that's one way of requesting a waiver. A second one is if there is a technical or design reason that's described in for design reasons specified in the resolution. And so that's more like a feasibility kind of an exception or a waiver request. And then the request for a waiver can only be granted if they demonstrate through clear and convincing evidence that the standard for the waiver has been met, and that the waiver, if approved, will be granted only on a case-by-case basis. So there's no general waiver out there. You can't waive for all applications. It's case by case and narrowly tailored so that the requirements of the chapter or the standards in the city council resolution are waived only to the minimum extent required to address the request. So in that case, say it was a waiver of a height requirement. They couldn't ask for, say, I'm just going to make up numbers, but say the height requirement was limited to 25 feet. They couldn't ask for 50 feet if they really only needed 35.
Understood.
Mike,
Okay.
can I follow up on that for a moment? A question.
Okay.
Mark, I'm confused. Gail, I thought an effective prohibition didn't mean that a particular application can't be granted, because there are going to be applications that ought not to be granted, but that it meant that as a matter of process, because you've adopted such onerous requirements, there's nowhere we can actually put up our facilities, period, in your town. You've stripped us of the ability to have any application granted. That's an effective prohibition. I didn't think it meant that every time you apply, you get to say, hey, if you can't grant me my application on this one that I want to do, you're prohibiting me. That's exactly the point of making an application.
If I may answer that, there are two ways that you can have an effective prohibition claim. One is that it's a facial claim. Basically, you've crafted an ordinance that there's no way anyone could ever, put a facility in. You've effectively prohibited because of the way you've crafted your ordinance. But the other way is that it is with respect to a specific application. And that's actually how that Ninth Circuit test developed, where they were looking at on a factual basis, this application can't meet such a standard, a height standard, or whatever it is in that community. And in order to get to not have to meet that standard, they had to show that that particular facility was needed to fill a significant gap in service, and that this was the least intrusive means, meaning least intrusive to the values of the community. So it was effectively waiving what the standards were in the community in the least intrusive way possible.
Right, but so if two neighboring buildings that are 100 feet apart from each other, one has a facility and the wireless company comes in and says, we want to put a facility next door, and you've got a 200-foot separation requirement and there's no gap in coverage whatsoever, the next door neighbor is getting the full benefit, they would be able to argue that they're effectively prohibited because you're not letting them put another facility in next door?
Well, they could make that argument, and then the question would be whether they've actually met the proof. And so that gets to 2 points. One is, what is the test that would apply to show that there is an effective prohibition? And that's where there's some uncertainty in the law at the moment. And the second is that if they can show it, then yes, they would be allowed to build that facility. If you were to deny it at the city level, then it may be that they would make that effective prohibition claim in a court, and it would be adjudicated in a court.
Sorry, Mike. Thank you.
No, this is complicated. So okay, it's getting late. I know a couple of things. Everyone wants to try and put this to bed tonight, and it's going to be tough. I'm going to start trying to put together some motions here, and I'm going to ask City Council for help. I do want to mention one thing first for the community to know. I think I told Scott and Nicole and Janet, but at a recent A&F meeting, that subcommittee is recommending, when we go through our budget process, a substantial expense to GIS map all the current facilities in the city of Malibu, more than map them, photograph them and check on their permit, find out which ones are there, which ones aren't there anymore, basically clean up the entire thing and build a database that we can then keep up with as we go forward. So we actually have a clue what's going on with the facilities in our city, which for a variety of reasons, we don't at the moment, mainly because telecom doesn't really do a good job of detailing a lot of these facilities as I understand it. Often their locations or addresses are wrong. Often they might have a facility there that's not permitted or is in disrepair, as we've seen. The photos we saw today show some of the things that would come up from that. So really, I think that's going to be very helpful as we go forward with our wireless ordinance and enforcement to have that. Now to try and put together some motions here. Maybe we should start a pool on when we can meet in person again.